G'day, it's Senator Malcolm Roberts giving the weekly wrap up this week from Brisbane. I've just arrived back from Canberra. Bloody hell, it's cold in Canberra, I can tell you that. I've got a very, very special and very, very interesting guest today. Really impressive man, one of the most impressive people I've met. But we'll get onto that in a minute. I've got to outdo him though, first of all. He's got a cap on with the Atlanta Braves, a big A. Well, I want to put this cap on. Can you read that? Black rocks, not blackouts. We need to keep burning coal. It's not. It doesn't. It produces carbon dioxide, but it's not a problem. It gives us the cheapest form of reliable energy, synchronous, stable energy there is. They're trying to gut our economy. Not only that, they're trying to gut our people, our coal miners. I want to introduce Simon Turner. G'day, Simon.
G'day, Malcolm. How are you? Thanks for having me on.
Oh no, thank you for coming. I only gave Simon very short notice because one of the things we dealt with this week, he had a really strong, powerful piece of information come to him last week, and we saw some despicable action in the federal parliament this week as well that'll hurt some casual coal miners. So, Simon, let's tell everyone about your story. Go right back to 2014 and the start of it, even before then when you first became a casual without knowing it, casual miner.
Well, I started in the coal industry. I left working in Sydney, and it was in the Hunter Valley where I started, and started with the company as a trainee. And being a trainee, you're a full-time employee. Now, once the traineeship had finished, I had all my full qualifications. I was a full-time employee, but then our roster then expanded and we worked a larger roster, which was the exact same roster as direct mine hire employees were working. But then I became
So you were working for a labour hire company that was employed by under contract by the mine owner. So you had two lots of employees on the site. You had those direct hire from the BHP and that, or the employer from the mine owner, and those who were through the labour hire firm.
Yeah, it's the same at most mine sites in the Hunter Valley in Queensland. This wasn't at BHP's mine. This was at another mine. It was Rio Tinto owned then, I think.
That's a good point you make. This is not what we're going to see is the tip of the iceberg. We're going to see this problem in the Hunter Valley that you have shown and blown the whistle on, and it goes right across Queensland as well in the coal mines.
Yeah, it's exactly the same. It's a carbon copy. That's how the industry has worked and ripped off everybody for over 20 years. Yeah.
Yep.
Once I did that, I'd worked. I was a full-time employee then, and that was a record held with Coal LSL because Coal LSL keeps all these records.
Coal LSL being the long service leave provider. So employers have to contribute to the Coal Long Service Leave Fund, and then after 8 years, you have the right to take long service leave at 13 weeks, and that's the payment for that is accumulated. So you keep staying on pay, but that's accumulated from the contributions by the employer in the previous 8 years.
Yep, the weekly payroll levy that's collected, and all the records
so it's a tax.
of the hours. Yep, it's a tax. Now, Coal LSL, they collect the levy. It's derived directly from the weekly pay of each employee. Now, it's not in numbers or hours or whatever they tried to mislead the Senate. It's directly in a dollar value. Now, the issue with that is if your weekly wage is wrong, Coal LSL is wrong.
And your super.
So is everything else. So is your super, so is the tax. Everything is wrong. Now, Coal LSL were keeping these records Coal LSL had 0 employees. Coal LSL wasn't doing it at all. It was done under a secret contract from about 1993 through to 2017 by the superannuation company for the industry, Auscoal Mine Super. That's just a name change.
So Coal Long Service Leave that was collecting all the money from the mining companies, employers, had no direct employees. They instead contracted out their admin to Auscoal, which is also Coal Super.
Exactly, yeah. They were carrying out all the functions, the admin functions and the roles that the legislation says Coal LSL has to do. Now, that company is owned by the CFMEU, 50%, and the Queensland and New South Wales Minerals Council at 25% each. So you've got the owners that are collecting, the owners of that company that are collecting all the Coal LSL levy and data and hours and the illegal classification. They're the ones, the CFMEU, they're the ones that know that casual employment is wrong. But in the background, they've been going out and doing
casual employment
enterprise agreements.
Casual employment isn't necessarily wrong. The way it's being done in the coal industry and certain other sectors like the airline industry is wrong.
Yeah, exactly.
Yeah.
The legal minimum of employment standards in the coal industry is the Black Coal Award. That's the legal requirement at minimum that someone can be paid and employed. Now, the reason why casual employment hasn't been added into the award for production and engineering roles is because when you work your 12-hour roster on a rotating roster that's 365 days a year, it is impossible to be a casual employee simply for the fact that you're in breach of the threshold, the legal threshold of a full-time employee. That's 35 hours per week under the award and 38 hours per week under the NES, which is the National Employment Standard. Now, we're above both of those thresholds simply on the roster that we work.
So it's illegal?
It's illegal, full stop. We've never been a casual employee. Now, more importantly, this was pointed out to people when we were working at Mount Arthur in a letter from the CFMEU. They filed a matter with the Fair Work Commission back in 2015. And both parties, the employer and the CFMEU, admitted in writing in the documents filed with the Fair Work Commission that we were all employed under the Black Coal Award because there was no enterprise agreement in place at that time. So this opens up a myriad of illegalities here because, one, there is no casual classification in the award. Two, there is no pay rate, so they just made up the pay rate that they were paying us. And that pay rate that they were paying us was less than the full-time pay rate that we should have been paid. So they effectively removed...
And less than the award too, correct?
Well, it is. That's what I'm getting to. It's all less than the award. We never received any of the shift loadings, the penalties, annual leave. None of that was encompassed in the rate of pay, and it's actually mathematically impossible for the 25% casual loading to cover all of those entitlements. So we've been ripped off twice. Now, we actually got some court documents for a court ruling that happened after this enterprise agreement was approved, which we can get to later. But this court ruling derived directly from the Fair Work Commission matter that the CFMEU filed. Now, that
from
ruling...
its own filing.
Yeah, yep, exactly. Now, that ruling had to look at who the actual employer was, our employer. Now, the court ruled that the actual employer was Chandler McLeod Group and the ABN ending in 052. The important thing with this is all of the evidence that was used in that court matter, and my name is actually on one of those documents in an affidavit used in that court matter with the person that it was for. My name is on that. So what this affidavit confirms, everything that I've said, the payer, like our employer, which was the ABN 052, they also paid the superannuation, the compulsory superannuation, which was going to Auscoal, Mine Super, same ABN. They were also collecting, and remember they were collecting all of the Coal LSL levy payments, which was being collected under 052. Our pay slips said we were paid by 052, the company. The ATO held documents all showed 052. Now, the important thing in this is they've identified the correct employer. We go down the road a little bit further, the Fair Work Ombudsman in 2018 sent me a letter and determined that there was no enterprise agreement that was capable of covering myself or the employer. So that once again doubles down and enforces that we're employed under the Black Coal Award, which the CFMEU run the matter for at the Fair Work Commission. Now, the important thing with that is when you're employed under the Black Coal Award, which is the legal minimum, firstly, we never received all those entitlements, and to this day we never have. But the second thing is we're a full-time employee under the award. You can't then be transferred to an enterprise agreement and paid as a casual when you work exactly the same hours. You can't just magically add in a classification. One, that classification doesn't exist in the award. Two, there's no pay rate for it. And three, we can't be a casual because of the hours that we work. Now, we've been underpaid the legal minimum the whole time this has been going on.
Right. Now that's a very good place to stop for a moment. First of all, the CFMEU is in the Hunter Valley, is in this up to its neck, up to its eyeballs. That's
Correct.
the first thing. Second thing is the CFMEU in the Hunter Valley is part owner, along with the Minerals Council of Australia, the New South Wales Minerals Council, part owner of the Coal Mines Insurance, which does the workers' compensation, which we're going to get onto in a minute, Coal Long Service Leave, Coal Super or Auscoal, which also does the books for Coal Long Service Leave. So the CFMEU owns these 50-50, or in the case of Coal Super, 25% with Queensland, 25%. No, the CFMEU is 50% of all of them, that's right.
Yeah.
So it's got access to all your figures. It also ran a case saying, complaining about in the Fair Work Commission, complaining about the use of casuals, but then it enabled these casuals to happen. That's what we've learned. But can you go back now? You've introduced us to some of the things that are wrong and some of the conflicts of interest and some of the opportunities for significant fraud. And I mean that word fraud. I've had a lawyer tell me in his view it's fraud, and other people have said the same thing. Go back to 2014 when you were injured. Because I was a coal miner at the coalface. When I graduated, I decided I better go and learn something. So I worked at the coalface, mostly underground, around the country, get experience. Then I worked as a mining engineer. Then I worked as a mine manager, and so I understood these things. Now Simon was hurt in 2014. So tell us about what happened there and what you were denied, the things you missed out. Because, mate, I can't understand how anyone could miss out in coal mines insurance.
Well, I was injured it was 2015 when I was injured. The compulsory insurer, and it's the legislated monopoly insurer for the coal industry, is Coal Mines Insurance. Now, you work in or about a coal mine, and this has always been the law that you are covered by Coal Mines Insurance. Your employer must have a workers' compensation policy with Coal Mines Insurance. Now,
correct,
that's standard.
And if your employer is a casual labour hire firm, as it was in your case, then they must have evidence that they are paying Coal Mines Insurance and give that evidence to the mine owner. So both companies are involved here.
Before they even get on site, before they have anyone walk in site, all this paperwork has got to be checked that it's compliant. Now, the evidence of that is that they did that is in the contract that we have a copy of between the mine and the labour hire company, and it clearly states that they've provided their correct workers' compensation policy. Now, when I was injured, I wasn't covered by the correct insurer. I was covered by the New South Wales statutory insurer, which means every other employer in New South Wales was paying their premiums for coal miners that were injured in the Hunter Valley.
So any small businesses in New South Wales, when you pay your workers' compensation insurance premium, you pay that to the New South Wales government. You are covering Simon's injury in the coal mining industry, despite the fact that he should have had a policy for Coal Mines Insurance. You should not have been paying for his injury, but you were. Yeah, that's
Yes,
fraud. That's
yeah.
fraud.
But not
And
only that, I'll just go into this a little bit deeper. We were on a New South Wales statutory policy. My occupation was listed as something totally different. I was listed as I was working in an office carrying out employment placement services, and my yearly wage was $28,000.
so they
And they
did that to reduce their premium.
yep,
It's
yep,
fraud
yep.
again. Not another issue of
There,
fraud.
there was over 270 odd on that mine site. We were all working in the direct day-to-day operation of a black coal mine. Here they are on that policy saying I worked in an office finding people jobs, which is totally untrue. But not only that, that policy legally since 2005 can't insure coal miners anyway. So that's why they couldn't say I was a coal miner. But then we've got years and years of exchanges between CIRA, which is the State Insurance Regulatory Authority, iCare, myself. It just went back and forth, and they just kept. They'd move the goalposts. They'd tell me something that was totally untrue, and just it was in direct conflict to all the paperwork. Because all the paperwork said I worked in an office, yet they said I was on a mine site when I was injured. Now, the ramifications of this is under the New South Wales statutory standard statutory scheme, my pay rate was reduced to $400 a week after week 25. Now, the importance of that is I was.
And where are you living now? Where are you living now?
I live in a garage at my mum and dad's house, so this is why I lost my home and everything.
Right. So the
I kept
financial
arguing.
financial
Yeah,
consequences on Simon have been severe, and all because people were fraudulent in logging him as an employee, as an admin worker working in an office.
yeah, that's correct. Yeah, I never
Fraud.
received any entitlement. I may as well have been pushing shopping trolleys around somewhere because, yeah, people like to say, and I've read all these reports to the Productivity Commission, the KPMG review, and especially the KPMG review into coal LSL. They say the extraordinary benefits that coal miners receive uh, are above and beyond any other industry. They might be if you're employed directly with the mine. You work for a labour hire company, you're basically uh, just above minimum wage, and you have every entitlement that cannot be removed by law has been removed.
Right. And that's so. So, tell us how you got injured when the rest of the mine was basically stood down because of dust, not unsafe working conditions, but you were continuing to work. You're doing the same job as the permanents right beside you, driving the same truck, and you got injured.
Yeah. I was hit by a coal digger, and I broke my back. I broke the back in two spots, which pinched my sciatic nerve and cluneal nerve, and there was a break in my left collarbone and first rib, which wasn't picked up till much later on when I had a full body scan. Simply because
So,
when I was taken to the hospital in an ambulance, they told me their X-ray machine was broken.
at
Which,
Muswellbrook Hospital.
yeah, which we find out later on that's totally untrue. It was never broken. They just didn't want me to have scans and that there and then.
And who
So
met you at the hospital? Was it a Chandler McLeod supervisor or a
no,
BHP
no,
superintendent?
no, BHP.
Right. So the
Um,
real relationship here between you, the worker, is not with Chandler McLeod in terms of the on-site work. You're getting instructions from BHP management.
Everything is done by BHP. Chandler McLeod, all they did was collect a timesheet at the end of each pay week, which was, I think they went and collected them of a Monday morning. That's it.
Right. So if I remember correctly, you were told to go back to work, sit on a cold steel bench, which would be terrible for back problems and collarbone problems. And then you were also warned by a BHP superintendent, do not report the injury or else you'll be fired. Correct?
Yeah, that's correct. Yep. Was told just come in, they'd make sure I got paid. And I did that for, I think it was about 4 or 5 shifts. And I was on some pretty heavy medication because of the pain that I was in at that point in time. And no one knew what injuries I had at that point either. I'd still haven't had the scans, and no one knew what I'd done, the damage that was done. And I'd go
And
in there and sit on a bench.
and having been at the coalface as a union member with the CFMEU and its predecessor, the Miners Federation, I know that there are few things more important to a good union than workers' compensation and accident pay. And they did nothing for you. In fact, they enabled this rort to happen because Chandler McLeod signed an agreement, or had an agreement with the CFMEU and the Hunter, that the CFMEU guaranteed that they would not take up any claims on behalf of workers at Chandler McLeod. Correct?
Yeah, that was agreed to in a letter. This was back when there was the issue at the Stanton matter, the Stanton hearing, which was originally filed, and then it shows in the documents that we have also that they needed to get this agreement through ASAP because there was a Stanton hearing. And what we know now is that all this was happening in the background, unbeknownst to all of the employees working out there. This was all cooked up between the two of them.
Between the Hunter Valley CFMEU and Chandler McLeod, they cooked this deal up. And it was part of, we've seen this letter. Simon showed us this letter from Chandler McLeod to the union saying that the union agrees to not pursue any matters on behalf of employees.
Now or in the future.
That's right.
Yeah, that's the important thing, now or in the future.
Thank you for the correction.
That's exactly what's happened. They haven't.
So the other thing then is that you have shown us New South Wales state government reports, annual reports for many years that show not one injury to a casual coal miner in New South Wales was reported in many of those years. And yet I met 8 so injured people. So these figures, these injuries are not reported, which is illegal. You must report them in the coal industry. You must report them to the government. These were not reported. The second thing is you were severely and critically injured, and you're now totally and permanently disabled. You weren't getting workers' compensation. You weren't getting accident pay. You're on a significantly lower rate than the permanent workers working for BHP at Mount Arthur. You're also being underpaid relative to the award. You're also not accruing your proper, correct coal long service leave provisions. You didn't get annual leave. You didn't get sick leave. So you were missing out on all your entitlements, all your protections, all your rights, and you're getting paid less.
Yep.
No, and you're casual, supposedly. You're called a casual, but you weren't getting a casual loading either.
No one. There's no casual loading in these pay rates. One, it can't be identified. Two, even if it could be identified, and what they try and what documents show that was submitted to the Fair Work Commission for the approval of this enterprise agreement, they're just it's like a 6-year-old with a crayon made up this fantasy that there's a loading in there. It's totally untrue. Now,
False.
The important thing is, how did this enterprise agreement pass? How was it signed off, and how did the Fair Work Commission give approval for something? And I'll give you an example.
Because what happens is the Fair Work, the enterprise agreements are agreements for an enterprise level, say at a mine, right? I just want to explain to everyone else. An award usually covers the whole industry sector. So you're working under the award as a basic minimum and under the National Employment Standards, which is a basic minimum as well. Now, there's nothing to stop an employer at a mine or at a business doing a deal with the unions or with the workers directly to come up with an enterprise agreement, so long as it's superior to the award. So long as it's superior or equal to the award. So, okay, keep going.
Yeah, the enterprise agreement has got to improve on and build on the award terms and conditions. Now, the important thing with that is this enterprise agreement that was supposedly passed the boot test, as two stat decks say within the application, which is now we know is untrue because the boot test was never applied to it, and the Fair Work
And the
Commission.
stat deck was signed by your employer, Chandler McLeod, and
Yeah,
by the CFMEU and the Hunter.
yeah,
Signed. We've
exactly.
seen the
Yeah,
signatures.
yeah. And in
Yep.
that stat deck, they also say that accident pay was removed from the modern award in 2014, which is also totally untrue. Didn't
Yep.
happen. Now,
So
the
keep going
important
with the
thing
boot
is
test.
the Fair Work Commission wrote to me and finally said that, and you've got a copy of that letter,
Yep.
the boot test was never applied to that agreement or a 2014 Gunnedah Basin agreement. It clearly does not pass. It's impossible for it to pass to start off with. But there are no documents that the Fair Work Commission hold that show that the boot test was applied, ever.
So let me fill in the details for people as well. Simon was injured 2015, almost 9 years ago. I got onto the case in July 2019, 4 years ago, almost 4 years ago. We have had so many people telling lies, so many people frustrating us. I raised the issue with the local member for the Hunter in the federal parliament, Joel, at the time, Joel Fitzgibbon, and he said, "At last, Senator Roberts, you've woken up to the casual labour hire rort." Yep. But as for the other stuff you're talking about, coal long service leave, workers' compensation, pay rates, that's all rubbish. So he deliberately, in my view, that's the only conclusion I can make. The conclusion is that he misrepresented what was going on. Simon had written to him 6 times. I wrote to him twice and got no replies. Simon got no reply. I hand-delivered to his replacement, Dan Repicoli, a letter outlining what was needed and what had happened. I hand-delivered it to Dan Repicoli's office in Parliament House. No reply. Yet I see Dan Repicoli and Minister Burke for the Department of Employment and Workplace Relations visiting the mines around the Hunter, talking about how Labor looks after people. So we saw Fair Work Commission obfuscating in Senate estimates. We saw the Fair Work Ombudsman Office obfuscating in Senate estimates. We saw coal long service leave obfuscating. And it's very difficult to drag people down to telling the truth. But eventually we've been starting to. They told us we were wrong on all this stuff. Coal long service leave, eventually the government, the coalition government under Morrison, admitted, and they got the coal long service leave review by PricewaterhouseCoopers. Then, KPMG. And then we find now Simon's got a letter saying, yep, the boot test was never applied. And not only that, Simon, the letter that we have a copy of says, we checked doubly.
Yeah.
We couldn't find it. And that means there is none. None.
Yeah.
None. Get over it. There is none.
Yeah. They said that I have everything that they have.
And he's got a hell of a lot of documents, I can tell you. This guy, Simon, and his mate Sam, how long have you been working on this? Since you first injured, pretty much?
Yeah. Well, the casual side of it was before I was injured. And this is where I started raising issues with the union at that point.
We could not have got where we are now, and I'm not going to take the credit for it because Simon and Sam deserve the credit well and truly, but we could not have got where we have got without their research. And I'll tell you, I'm not blowing smoke up his backside. It is phenomenal research. This guy is super skilled, and he's determined, and he doesn't say no, he just keeps going. Setback after setback after setback. And you probably couldn't have got as far lately without us, so we've been working together. But I just want to compliment you and express my appreciation for the quality of your research as well as the volume of your research. Your knowledge, if you ask him a question, I'll get onto that later, ask him a question about coal long service leave or some of the coal mining coverage issues, got it like that. Okay, mate, keep going. So there you are, injured. No one will touch you. They're scamming you on workers' comp. They're scamming you on accident pay. They're scamming you on pay rates. They're scamming you on leave and basic entitlements and protections. They're scamming you on long service leave. No casual loading. There you go.
So what happened then was I contacted Coal LSL just to check on my long service leave, because when you're on workers' comp in the coal industry, you still accrue long service leave. Now, the issue with that is when I rang to find out, she said, yeah, just hang on, I'll check. And she come back to me, she said, oh, you're not accruing any at the moment. I said, why? She said, well, you were sacked. I said, when? So she told me the date that I was sacked, and it was the 7th of the 1st, 2016. Now, my injury date was the 12th of the 12th, 2015. So I was sacked illegally. The important thing is I was never told about this. I found out for myself via Coal LSL.
So you were sacked, what, 2 or 3 weeks after you were injured?
Yeah.
And after you were told, this is third world stuff. After you were told, you report this, mate, and you'll be sacked. You didn't report it, and you were sacked anyway. And they didn't tell you. Your employer did not tell you.
No, I found out through Coal LSL, and then I got a copy of the separation certificate. Now, on that separation certificate, it was dated the 7th of the 1st, 2016. The letter I've got from Mine Super, which is Coal LSL, it confirms the termination date was the same date. There's a chain of emails between the employer and Coal LSL asking where I am, and they say that Simon hasn't come back to us. He went off on, I forget what date it was now, just off the top of my head, but has never come back to us. Now, in the separation certificate that I asked for how does Coal LSL know that I was terminated? There's got to be a document chain to show that I was terminated and not turning up for work, right? Now, what happened was, they say I was terminated on the 7th of the 1st, 2016. There's a section just down below that which says, has a workers' compensation claim been made, or will there be one made in the future? And they've ticked no. Now, this form was completed and filled out 5 months after the 7th of the 1st, 2016. Now, that whole time, I was on workers' comp.
So it's fraud.
It's straight out basic fraud. They say no workers' comp claim has been made or will be made in the future. And that whole time, I'm on workers' comp. The whole time.
And you're employed under an illegal enterprise agreement that never passed the boot test. The boot test wasn't even applied. And the whole thing is illegal under the Black Coal Mining Industry Award. The whole thing.
Yeah.
And Auscoal or Coal Super does the same company does the books for Coal LSL, does all the admin work. So they have access to your records.
Everything.
Which raises serious questions, and they're owned 50-50 by the CFMEU and the Hunter.
Yeah. Now, the important thing with this here, what we've just touched on now, under the New South Wales statutory scheme, which I was covered under, there's a thing called a pre-injury. It's called a PIAWI. It's your pre-injury average weekly earnings. Now, under the coal mining workers' compensation scheme, a PIAWI does not apply to a coal miner because you get 78 weeks if you're injured that long. You have 78 weeks. This was at that point in time when I was injured, full pay. That's called accident pay. Now,
he's correct. I know that from the coal industry.
Now, the thing is, I was in a statutory scheme illegally. I'm a coal miner, which none of the paperwork that they're in this claim says that I'm a coal miner. They say I work in an office. But they also then come up with the PIAWI, right? This was done 2 days after I was injured, that I was earning $92,000 a year. Now, mind you, the important thing this now gets into is the ATO and records.
Australian Taxation Office.
Yeah. Now, it was impossible for my employer at the time to say that I earned $92,000 because
your employer being Chandler McLeod. Your employer being Chandler McLeod.
Yep. Now, the reason that they couldn't have known this was simply the fact that the year that they signed us over, because we were employed with Tessa at the mine site, and they lost the contract, and we all had to go over to Chandler McLeod. So there wasn't a full financial year in there. Now, when they do a Piawi, it's the 12 months prior to when you were injured. Now, they came up with $92,000. My tax records can not be accessed by them whatsoever. Same as anyone in Australia. You're the only person that has access to your tax records, right? Now, I did that on the MyGov website. I looked at all of my PAYG summaries and everything, what I was paid for the years, who paid me. Now, I thought, hang on, how can they say the Piawi pre-injury average weekly earnings is $92,000 when this PAYG summary clearly shows here I was paid 66.
So that's 26,000 above what you were actually paid, and that's almost 50%.
Yep. Now the important thing is, how did Chandler McLeod know when all of the documents, the PAYG summaries, pay slips, ATO held records show 66 grand? Where did they pluck the 25 from? Now they can't access my ATO records because guess what? I filed this with the ATO and it went through several departments to look at and to scrutinise, and they said, yep, we know what's happened here. Someone's added $25,000 from when you were employed with Tessa to this PAYG.
So that's another example of fraud.
Yep. But how did they get access to my ATO records? They can't. And this is what the ATO is trying to find out now. Who accessed my ATO records to change that yearly pay amount?
And then the other question people will be really interested to know is the Fair Work Ombudsman opened up an investigation in 2018 into some of the things that you were raising, and they came back with a certificate saying your employer was Ready Workforce, where in fact the Stanton case, the eligibility judgment, your employment record, your pay slips, your Australian Taxation Office summary all said your employer was Chandler McLeod.
Yeah, correct.
So how the hell did the Fair Work Ombudsman create or come up with a document that said, no, you were employed by Ready Workforce?
Well, the Fair Work Ombudsman that was doing the investigation, he had all of these documents. He also had the court ruling. He had everything.
Wow.
Right? Now, they came back to me and provided me with a letter and said, we've had a review of this. You're not entitled to anything under the award because you weren't employed by Chandler McLeod. You were employed by Ready Workforce.
Wow.
With ABN 037. Now, I've got a letter from the ATO saying that there was no employment relationship with that ABN entity 037 at all.
You've got it. So who is that from?
The ATO, the Australian Taxation Office.
The ATO said you had no employment relationship at all with Ready Workforce, but the Fair Work Ombudsman came up with a document that said you did.
Yep. Now, I asked him how did he arrive at this decision, and he said, well, I was given your PAYG summary. I said, okay, from who? He said, from the employer's lawyers. Now, I said, can you send me that? I said, because I've got my PAYG summaries here and I've got access to MyGov. So he sends it through and I've looked at it and I thought, holy shit, that's a different ABN to what's on the ATO website and to what I've got and what the accountant who did my tax returns has got. Yep. So I then contact this internal intelligence at the ATO that I've been dealing with. And she says, yeah, this is a serious issue. I then tell the Fair Work Ombudsman that this is a fraudulent document. I then have to sign an ATO whistleblower form. And to this day, I still haven't heard anything back about this issue and how they used a fraudulent document that's in direct conflict to court rulings, the contract at the mine site, my superannuation, my weekly pay slips, coal LSL, everything is in direct conflict to one document that this investigation used to say I was employed by a company that never employed me.
Right, and then there are other conditions, other really serious questions as well. The whole way through, we saw that coal long service leave had atrocious governance, and we kept prodding them and prodding them and prodding them on that. Yeah. And then we find out they're very, very shoddy. And we also find out then that their admin work is done by the same people as Coal LSL, is Mine Super and Auscoal, which is again owned 50% by the CFMEU. So the CFMEU and the Hunter has access to your records.
Everything. They had access to everything.
And also,
but not only that, the employer, they've also got billions of dollars with the ATO, right? Supplying staff, computer systems, a myriad high-level people. Yeah.
Chandler McLeod has
contracts.
Yeah, Chandler McLeod has government contracts for many departments, including the ATO, Australian Taxation Office. And I think the figures you gave me for 4 years up to about 2020, Chandler McLeod was paid $2.4 billion.
Yeah.
That's correct?
That's just in that entity's name, that ABN 052.
Chandler McLeod, okay.
Yep.
So we've got serious conflicts of interest here. We've got many instances of fraud. We've also got the arbiter and the regulator for the Fair Work Act, which is supposedly for protecting employees and employers. The Fair Work Commission is denying that you would have failed the boot test, denying repeatedly, correct? And they've said the same to me in Senate estimates. And now we find a letter from the Fair Work Commission saying that the employment agreement, the enterprise agreement under which you're employed, never was subjected to the boot test.
No, there was no agreement. It's called the Agreement Analysis Summary, and the boot test is contained in that, and this was never applied. Now, the important thing was that came out in Senate estimates, which Murray Furlong mentioned. It was legislation.
He's the head of the Fair Work Commission, Murray Furlong.
Yeah, the general manager. Now, the important thing with that is, when I went back to the Fair Work Commission after hearing what they said at estimates, I get a response from someone that was very high up, and this person was actually an associate to the president of the Fair Work Commission, Ian Rossett, at one point in time.
Yeah, retired.
This person tried to tell me that, it doesn't exist in your case with that agreement. It came in effect in 2016, and it might have been used in 2014 when we were trialling it, but it never applied in the period of 2015 when your agreement was done. So I went back to her and I said, well, I don't think that's correct, because I've got documents here that show everything is the exact opposite of that. So then I then get the letter from the Fair Work Commission saying that the boot test wasn't applied, never been applied to those agreements.
Last week, you got that last week.
Yeah. Now, the thing is, Sam went back in and got some information, and we can now show that there's other agreements that were done exactly right at the very same time as the 2015 agreement, and we can clearly show this. It's not the coal industry, and there was agreements picked either side right at the very same date. They had the boot test applied. The commissioner expressly asked for it to be applied.
And it was.
Yeah, and it was.
Yep. So
there's a whole crew that there's a checklist and a whole system that staff at the Fair Work Commission compile and get before all those documents for the approval of an EA goes to the commissioner and the commissioner's associate and staff. And if there's any issues flagged, then it's stopped there and then. They go and say, well, right, you need to show us this, this, and this. If you can't show us this, then, it doesn't go ahead.
Right. Simon, I asked you to come on because of the fact that we had some legislation passed yesterday in a blitz and also because the boot test notice that you got, there was no boot test to your enterprise agreement. And I said I didn't know whether it be 10 minutes or an hour. What we normally do on this show, and I forgot to mention this, so it's up to you entirely, is we throw it open to questions after about 15 minutes, half an hour, depends about how many topics. So we've been going about 45 minutes now, and so are you willing to just stay on and answer questions?
Yeah, if anyone wants to know something, because I know there's a lot of mistruths and things that are put out there with it, whether it's in the Hunter Valley or Queensland, of what's gone on and how things have happened. And yeah, I'm happy to sit here and answer questions.
Okay, great. So get your questions ready. And I just want to make a couple of other points before we do. Yesterday, there were 20 bills passed through the Senate without debate, gagged, guillotined, in 20 minutes. There were 20 bills passed in 30 minutes. It was just one after the other. Just vote, 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 vote. We were opposed to the one of the bills, the Fair Work Act bills, amendment bill, because it included provisions that Simon and Sam told us, and our lawyers confirmed, were not fair to casual miners. So what Labor appeared, and it got through, because everyone else except for it all got through on the voices. No divisions. And so what appears to be happening, well, you tell them what's happening with that coal long service leave legislation, Simon.
Well, that Schedule 6 is merely to cover up everything that's happened from 1993 to 2017 and beyond. What they've done is they've actually just rewritten what's already in place. They go into calculations of 35 hours per week. Now, that's straight out of the award. You've got to remember, and this is identified in the KPMG review, that the whole coal long service leave scheme was underpinned by the Black Coal Award. Now, the issues here in this is all they've done is rewrite what's already in existence,
and that's wrong.
And it's wrong. But what they're saying now is, if we can identify a casual loading, then the casuals will be paid that rate. Now, this is where you get an issue. What they were doing, right, the levy was collected on the full weekly wage, right, which was supposedly a loaded pay rate with casual loading. Now, when people, and a very limited number of people would take their long service leave, these labour hire companies would pay the long service leave at the base rate of pay that was listed in their agreements, right? So they said, we don't have to pay the loading or anything else. So where is that money disappearing to? Right. So this
very good question.
Now that they've tried to add in there, if we can identify a casual loading, you'll get paid that as well.
Right.
Now,
so
it's laughable.
If you can identify it, good luck with that one. So what they're doing is exactly as you said. That part of the bill that went through yesterday appears to be a smokescreen to hide the disadvantages suffered by labour hire miners and to hide past shortcomings of coal long service leave. They want to, instead of fixing it, they want to bury it to make it legal. So, so that's why we did not support that. But as I said, it went through on the voices. Second thing before we get into questions is that I'm writing a letter. It should go today to Tony Burke, the minister, putting him on notice that we know the facts now well and truly. And I'm saying here, what will fix this? You don't need to do anything fancy. Simon pointed this out to us. You don't need anything fancy, because I'll read things in here that we got highlighted in my letter. This meeting between the CFMEU and Chandler McLeod, the employer, took place after the Fair Work Commission hearing on 23rd of March 2015, which was a hearing to deal with a dispute for the failure of Chandler McLeod to meet the terms and conditions of the Black Coal Mining Award 2010. They were wanting the CFMEU to cover it up. Excuse me. The employees involved in this dispute have never been paid all statutory legal entitlements that the Black Coal Mining Award confers. Never been paid. So Tony Burke and your staff, you can fix this for Simon, starting, and many other employees in the coal mining industry by simply applying the award. That's what's supposed to be your job, to make sure they're protected.
Can I say, Malcolm, what the award value was at that point in time when all this happened? the award value on my work roster, which is exactly the same as the BHP direct employees work roster, exactly the same. If I was correctly paid under the award with the entitlements and loadings and everything, it was just on $140,000 a year. Now,
So they were diddling you.
You got to add on to that as well the 6 weeks annual leave and 20% annual leave loading, and you're paid, forget about coal bonuses and that, because we've never been paid any of them.
But, well, you should be getting that too.
I was paid $66,000 under an enterprise agreement that was supposed to be better than the award,
and that the CFMEU and the Hunter signed off on. Stat Dec. So what I'm saying in my letter to to Tony Burke, the Minister for Workplace, Minister for Employment and Workplace Relations, we need full application of the law as it stood when these breaches occurred. All of the necessary lawful protections were in place to stop this abuse of casual miners, yet the Fair Work Commission and Fair Work Ombudsman went around it, or at the least ignored it. Well, we don't need any more fancy legislation. I've got my legislation for same work, same pay. What Simon has pointed out is we don't need that, but I'm hanging that over the heads of these employers and the federal government, because we need this fixed. If you're not going to fix it, you're going to continue to be dishonest, then we will put in place our legislation and force you to come up with your own. So we've had some meetings recently with employers. At last, they've been running from me, but we've had meetings last, and Simon was pretty hopeful with that. So we need. The other thing I want to make before you ask questions is the Fair Work Act is supposed to protect workers. It was introduced by Julia Gillard. Workers, employers, unions. The Fair Work Act does not protect workers. It protects the Industrial Relations Club, which consists of lawyers, consultants, union bosses in some, not all, some large unions, multinational companies who want to come in here and rip workers off, and it favours industry associations, employer associations. That's who it favours. And the Fair Work Act is so damn complex, so detailed, so prescriptive that workers, small businesses, cannot understand it, haven't got the time to go into the details, haven't got the money to pay for lawyers, and the big companies and the big unions who are monopolies in their sector and therefore not accountable, they have the pockets and the knowledge to hire the workers that can flog people like Simon. We won't go into what's happened with lawyers, Simon, because you've been let down horribly. A barrister who's been working with us is appalled at the shonky treatment you've had, lawyers committing fraud with you. So everything has broken down. We've also been onto the state government in New South Wales. They have refused to touch it. But we're now starting to get into some light. If anyone's got any questions, we'd love to hear from you, because we need a new set of laws. Replace the Fair Work Act with a very simple legislation that honestly protects workers and employees, employers and unions, and that if you breach any of those provisions, you go to jail. Right now, you just get a lawyer and get off it. So there's a question, Simon. I don't know if you can see it. 007 says, "Are there any unions worth a damn anymore?" Over to you, mate. I've got a good answer on that one.
Well, if they do carry out their roles and responsibilities as per they say and what they're required to do, you can clearly see here that we've been, I wouldn't say let down, it's too nice a word.
You've been shafted.
We've been shafted. And the only person that could do that was the Mining and Energy Union.
Yep. And
can I just
007?
Yeah. The Fair Work Act, and the NES, they're the instruments that give the Fair Work Commission and the Fair Work Ombudsman their power and authority to deal with matters, right? Now, they simply haven't enforced those powers and their authority to rule on what they should have ruled on under the Fair Work Act. They do that in 2014, and we're not sitting here today having this conversation. There's every issue would then be resolved.
Okay, my answer to you, 007, is that there are some very, very good unions who actually still look after workers. Most of the big unions do not, because they've got now into politics, they've got into power games, they've got into superannuation. They're making multi-billion-dollar, they're leading multi-billion-dollar industries and corporations now themselves. What they do is they look after their own personal power. Many of the union bosses, not all. The TWU seems to be pretty good, because it also has a high component of small businesses within it. There are many truckies who are employees and many truckies who own their own businesses. So what's happening is that you've got major unions having no competition in their industry sector. For example, the CFMEU and the mining division. And where you don't have competition, you have a lack of accountability, because workers are told basically, if you don't like it, tough. That's it. Now, there's also, so there are some traditional unions that are very good. Transport Workers Union seems to be decent. You've also got the new Red Union in Queensland, which is teachers, doctors, nurses, health practitioners. They're very good as well. Their dues are half the rate of the Queensland Nursing Union. And the Palaszczuk government in Queensland is hammering them to try and make them illegal. Because what happens is the major unions, traditional unions, are feeding piles of cash into the Labor Party. And so the Labor Party is doing whatever it can to maintain the union monopoly. And that's where the problem is. We've got to have more competition amongst unions, because with competition comes accountability. Next question. I'll read it out for you, Simon, in case you can't read it. Fair work are useless. They are... Okay, you want to have a go at that?
Yeah, I'd agree with that comment. Simply because they pick and choose who and when and where they want to enforce and carry out their authority and responsibilities. If it's coal mining and labour hire, they've done nothing that they should have done. Other industries and that, they've cracked down, and I know cases where they've cracked down on small businesses, which is disgusting, I think, because small businesses really struggle with the Fair Work Act and awards and enterprise agreements, especially if they don't have people within the union movement themselves. But you got to remember that when they try and do all this, they're relying on support and what they can find off websites. They can't go out and hire HR or IR lawyers or anything to deal with this. They're just doing what they think is best. Now, they're the ones that are clearly been, and you can look them up on the Fair Work Commission websites, they've been prosecuted and held to account. You've got these multi-billion-dollar companies, international companies that have extensive resources, and they invent these computer systems to do payroll and everything else. They specialise in it. They even sell computer systems and everything to the federal government. They employ specialised staff and in-house lawyers to make sure everything's right. But you know what? They don't. And Tony Sheldon talks about we've covered the loophole. It's simple as this. There is no loophole in the coal industry. The Fair Work Commission and Fair Work Ombudsman simply hasn't enforced the law. That's it. There is no loophole. They enforce the law, then none of this happens.
Simon, I just realised I've got another interview coming up at 4:15, which I've got to be ready for, so I've got to get into that. We'll have you back, if you don't mind, one day, and not too distant future. Fine. For everyone who's looking for the usual collection of issues that we go through at this time every week, I've got some rippers, so we'll just have to do it next week. But I'll answer that question about the Fair Work Commission. I think the Fair Work Commission is useless. I think probably some of the people employed do a good job, but but the other thing, Simon, it raises the question: is there someone at senior levels who are getting into the Fair Work Commission, and doing something illegal, fraudulent? So that raises serious questions. I don't accept that they're just incompetent. It raises questions with me that they're willfully negligent. That's what I would use. Because
Yeah, I agree.
what you have done is put so much information to them. So I've got to go. There's one thing I was going to say, but I've forgotten. Mate, thank you so much. You've been going through this 9 years. We've been with you for 4. It's a real pleasure and honour, and I mean that, to work with you. We're going to continue. We will hound this down. We've got three aims we're sorting out, and we will keep those aims until we get them.
Yeah, I'd like to thank you and everyone else within One Nation, and I know it's a big job, but I think we're getting there, and we'll finally get there pretty soon.
See you later, mate. And despite the coal employers being sometimes, remember this, the coal industry rocks. So, mate, don't hang up, because once Sheena cuts us off, don't hang up, because it takes a while for it to download.
Yeah.
So I'll say goodbye to everyone, and goodbye, Simon. Thank you very much.
Thank you. See ya.